Brian Beckwith was a partner at a large London firm. He was accused of sexual misconduct on 2 occasions involving a junior female employee referred to as Person A. Mr. Beckwith was her supervising and appraisal partner. The first incident took place in May 2016 during a work social event. The second after another work social event in July 2016. Person A had handed in her resignation by the time of the second event. The SRA alleged that Mr. Beckwith had breached Principles 2, act with integrity, and 6, behave in a way that maintains the trust the public places in you and in the provision of legal services of the SRA Principles 2011. Mr. Beckwith denied the first allegation of sexual misconduct. The tribunal ultimately found the allegation not proved, and it was dismissed. In respect of the second allegation of sexual misconduct, Mr. Beckwith's position was that Person A consented to the sexual encounter, while Person A's position was that she was too intoxicated to consent. The SRA considered that consent was not an issue that needed to be determined, while Mr. Beckwith considered it to be a central issue and that, without a determination as to consent, the tribunal would be unable to consider whether the respondent's conduct was in breach of the principles as alleged. The STT held it was not for it to consider matters that had not been alleged. The STT found that whilst Mr. Beckwith was in a position of authority over Person A, there was no evidence to support he had abused that position. In the absence of any finding as to lack of consent or abuse of power, the STT nonetheless went on to find that on the underlying facts, Mr. Beckwith was in breach of Principles 2 and 6. Mr. Beckwith was fined £35,000 and ordered to pay costs of £200,000. On Mr. Beckwith's appeal to the Divisional Court, the findings under Principles 2 and 6 were set aside. The Court's judgment is of application beyond sexual misconduct cases and raises a number of issues of wider significance, including: firstly, the Court found that the SRA principles are not of overarching application. The Court's interpretation seems to have been that the principles in the Code have to be read as one, and you cannot have a breach of a principle if it is not provided for in the Code. Whilst the Court made clear it was not dealing with the November 2019 SRA standards and regulations, it is difficult to see how the approach would not also apply to them. Second, on the facts of the case, the Court formed the view that in the absence of a finding of lack of consent or abuse of power, and based on its analysis of how the scheme works, there was no basis for any finding of misconduct. Thirdly, the Court drew a distinction between conduct that undermined public trust in the profession and conduct that would be generally regarded as wrong, inappropriate, or for the person involved disgraceful, and thereby clearly cautioned about interference in private lives. It also observed that it would not be right for all or any aspects of that person's private life to be subject to regulatory scrutiny, and any action needed to be grounded in the Code and be relevant to the practice as a professional. Fourthly, any case has to be well grounded and beyond collective disapproval or criticism. In the view of the Court, popular outcry is not proof that a particular set of events gives rise to any matter falling within a regulator's remit. Fifthly, the extent to which there is an overarching professional disciplinary law.